Hello, Hans.
Good afternoon, Commissioner.
You're running this meeting, correct?
I am.
Thank you.
Just working on some waiting room people to join us here.
Okay.
Okay, I'm noting it is now 2:02. I'll keep monitoring. Anyone else that's looking to come into the waiting room? Good afternoon, everybody. My name is Hans Muller. I'm with the Office of General Counsel for the PRC. Before we go on the record, Melissa, as I indicated to you before, I want to do a little bit of housekeeping. Obviously, everyone, due to the circumstances that occurred within the Office of General Counsel, losing our law clerk and the retrieval of information that may or may not have occurred, I do want to take a little bit of time and make sure everyone that is expecting to be on the speaker list today is on the speaker list. We did our best to try to retrieve information, but since this meeting was initially scheduled for May 17th and moved, I'm not positive that I recorded everybody who had previously asked to speak. So what I'm going to do is my speaker list is quite a bit shorter than I anticipated. So what I'm going to do is read off the names of who I have right now as expecting to speak. And rather than everyone raising their voices at once, if everyone is familiar with the way to raise your hand on the participant list, if I don't call your name, raise your hand and I'll acknowledge that. And once I get through that, I'll then look for verbal cues. So once again, I apologize for the delay, but we are just really dealing with still coming to grips with our loss and moving forward with all the information that we have. So that being said, like once I read the names off here, I'll then look for if you felt you should have been on the speaker list, raise your hand on the participant side here, and then I'll go through the names of who I see has raised their hand and add them to the list. And then after that, I will take verbal cues from people. So here's who I have right now. Jim Desjardins, Catherine Wiskowski, Steve Condon, Debria Terwilliger, Leon Viveros, Michael D'Antonio, Anastasia Stevens, Ron Moss, and Sky Stanfeld. If I did not call your name and you were expecting to be on the speaker list, go ahead and raise your hand. If you are aware how to do that with Zoom.
You want to explain how to do it? It's just down there on reactions at the bottom. If they
right there, let me look for them. Yeah, they've moved it around. If you click down below, if you click the three buttons that says more, you should be able to get the reactions. And that should give you the opportunity to essentially raise your hand.
or just hover down there. Hovering works for me. I don't have three buttons.
Okay. Since I'm streaming the movie, I might have a slightly different control panel.
Mm-hmm. Yeah.
Right. I am not noting any raised hands, so I will take a verbal cue from anybody who felt like they should have been on the speaker list, but I did not mention. Make sure you unmute yourself before you do a verbal cue to me. Okay, I am hearing none. So my speaker list is intact, and which is a considerably shorter list than I thought we'd have. So that being said, my original mark of 10 minutes per speaker will stand. I think most people have indicated that they will be shorter than that, and I see no problem allowing for 10 minutes. We've scheduled this for 3 hours, and this appears that it won't run that long. 2 more admits. So with that, Melissa, let's go ahead and go on the record.
Very good.
All right, welcome everybody. We are here for the PRC public hearing in case number 21-00266 UT in the matter of a rulemaking to repeal and replace Commission Rule 17.9.568 NMAC, interconnection standards for electric utilities, and the associated interconnection manual. This public hearing was originally scheduled for May 31st, 2002, and by order of the commission extending it, it was moved to June 17th, 2002 at 2 p.m., which is today, and it is currently 2:08. I have requested for speakers today, and I have a total of 9 speakers who have wished to make a comment. Once I ask for comment, I would appreciate everyone keeping yourself on mute until you are called upon, just so we don't have background noise interfering with any particular speaker. At the end of the speaker list, I'll open up the floor again for discussion. For anyone that may feel they want to do additional comments. But until that time, just please respect the time of the speaker that is called upon. So let me go ahead and call the first speaker, Jim Desjardins with REIA. Jim, go ahead and unmute yourself.
Thank you, Hans, and good afternoon, commissioners. My name is Jim Desjardins. I'm the Executive Director of the Renewable Energy Industry Association of New Mexico. We're known as REIA. We have about 50 members, a very diverse association that goes back to 2004. We started this process about 1.5 years ago when it was brought to the attention of the commission that homeowners were being denied the right to self-generate their own energy due to P&M distribution lines being at capacity. Since then, we've had 16 workshops, numerous other opportunities for stakeholders to provide input, and we are very thankful for that. We've been fortunate to have numerous stakeholders weigh in, including the City of Las Cruces, the Attorney General's Office, national organizations like the Solar Energy Industry Association, Coalition for Community Solar Access, the International Renewable Energy Council, known as IREC, and many developers. So clearly this is a very important topic for a lot of folks. And it's a testament to the commission that the docket has been very broad, but also very in-depth. And speaking for myself, it's been a great learning experience. I do think there's a few issues that really stand out due to their importance, and I'm just going to go through those briefly. One is non-export, and REIA believes we need to have clear evidence-based standards that encourage the use of storage, controls, smart inverters that will basically allow for non-export systems. And we believe this would be a pathway to open those closed distribution lines. Second is on the rule and manual. We strongly believe that there needs to be one document. And IREC has done a very good job of speaking to that. And one of the things that was in comments, I believe from at least one, maybe two utilities, was the ability to have utility-specific manuals. We believe this would be a grave mistake. There's 19 utilities in New Mexico, and we believe it would just be basically impossible to work through something like that. We believe there needs to be a realization that there's going to be new technologies on the horizon, and we need to have processes that will integrate these. And the fact that there's going to be new technologies coming, and of course there always will be new technologies coming, should not allow us to hesitate to move forward on this very important docket. Cost allocation is a huge issue nationwide in our industry, and we believe the current process of cost causation being how we determine how to pay for improvements to the grid is a very outdated system and will prevent us from moving forward. We are happy, we applaud the commission for addressing this and putting provisions in place. The joint commenters, which includes REIA, put in some suggestions for that, and IREC also, I think, made some very good thoughts on that. Hosting capacity is something that also we believe is very important. In one of the workshops, a commenter made the point of you can't fix what you can't see. And so we very much want to see and have information so that we can make improvements and to best use resources when they're on distribution lines. And transparency. We strongly believe that transparency is vital. We need information from utilities such as a public queue. We need information on where distribution lines are at capacity. We need information on status of projects. We basically need a lot more information. Having said that, I want to emphasize that REIA wants to work with all stakeholders, especially our electric utilities, so that we can have a grid that best allows for the integration of distributed energy resources and will best enable New Mexico to have a future of 100% renewable energy. And we believe that we need to move forward on this now as soon as possible. Thank you so much for the opportunity.
Thank you, Jim. Appreciate your comments today. Next speaker is Catherine Wiskowski, Sonova. Catherine, go ahead and unmute yourself.
Hi, I'm Catherine, the Interconnection Policy Advocate for Sonova Energy. I thank the Commissioners Hall, Byrd, Massas, Vicente, Aguilar, and Fishman for this opportunity to present on New Mexico's interconnection rules and manual. Sonova Energy International is a leading residential solar and energy storage service provider with customers across the U.S. and its territories, including New Mexico. We see the importance of working in the great state of New Mexico for its abundance of sunlight and robust utility infrastructure. And I am here today to demonstrate the importance of your support for both Interstate Renewable Energy Council and Solar Energy Industry Association, Renewable Energy Industry Association, and Coalition for Community Solar Access recommendations to the interconnection rules and manual, as well as additional comments on rule suggestions. Specifically, I want to voice our support for IREC's battery interconnection procedures. They provide a toolkit in the comments and specifically ask for interconnection applications to consider export capacity instead of nameplate capacity in the interconnection agreement. Using nameplate capacity can hinder projects from being developed even if the battery does not export at a rate that affects the grid. So customers that are looking to add resiliency to their home systems are unable to do so without paying for distribution systems because impacts on the grid are being calculated with the wrong type of capacity. Additionally, customers can avoid upgrade charges by utilizing smart inverter technology. This technology allows system exports to be curtailed so larger distributed energy resources can be installed with minimal impacts. Furthermore, we support the development of hosting capacity analysis maps. Customers need more transparency on DER penetration and grid capacity. They should be able to see if their project will require an upgrade before applying and see if battery storage and smart inverters could significantly lower their cost of interconnection. Sonova supports the recommendations from SIA, RIA, and CCSA for standardization and transparency of upgrade costs. Utilities should provide a public list that's updated yearly of standard equipment costs for upgrades. It helps customers to understand what they can reasonably expect to pay to interconnect. And utilities are experienced in completing distribution upgrades and need to provide reasonable estimates to customers based on standard equipment costs. Estimates that vary greatly from the final cost to upgrade may create an unreasonable financial burden for customers and may increase distrust in the public's perception of utilities and their practices. Continuing clear communication between the utility and the interconnection applicant is vital. The Commission should not leave it to the utility to put in a reasonable effort to ensure communication and should therefore mandate it. Utilities should utilize an online portal with simple steps for interconnection. Applicants should be informed of completed steps and be provided relevant documentation during the process. Residential interconnection customers can't be expected to understand this process completely, so standards for communication need to be established. The utilities should also have requirements to communicate with applicants about impending deadlines that may be missed. Utilities should be required to communicate delays the moment they're aware of them and explain the reasoning for such delays and provide an estimated timeline of completion. The timelines IREC recommended are reasonable and beneficial to the customer because they promote accountability and transparency of the process. There should be a cost sharing mechanism for distribution system upgrades. Many states have realized that cause or pay systems hinder renewable energy development and are adopting different methods. New York has implemented a solution where the utility pays for the entire initial upgrade cost, and then developers later pay the utility for the capacity that they are using on the areas that had upgrades. Another option for residential systems is to have the utility pay an amount for upgrades triggered by residential systems, and then have the residents pay the remainder of what is left of the upgrade cost. This increases access and equity to DER systems for customers that do not have financing to pay for transformer upgrades. Finally, PNM has asked for individual manuals for each utility that supersede the rule. This is unreasonable and defeats the purpose of having a rule. It also harms the customer by allowing the utilities to dictate their process without oversight, and makes this rulemaking process irrelevant. So in summary, I'd just like to reiterate the importance of proper interconnection procedures for battery storage systems, the adoption of hosting capacity analysis maps, transparency and upgrade costs, expectations of communication, developing a better approach for cost allocation, and solidifying the authority of this rule. I thank the Commission for allowing me time to present on this rulemaking docket. Thank you.
Thank you, Catherine. Steve Condon, go ahead and unmute yourself. And I'm not seeing Steve Condon as having an identification on the participant list unless it's a phone number. Having not heard Mr. Condon reply, oops, let me hit some, oop, there he is. Hold on one second. Admitting him now. Mr. Condon, I see that you are now a participant in here, and it is your time on the speaker list to talk. If you could go ahead and unmute yourself.
Thank you. I'm actually just joining to. I'm Steve Condon. I'm with a group called Energy Well. I'm just here to listen and observe, participate if I can.
Okay. Thank you, Steve. I wasn't positive whether you wanted to make comments or not. Thank you.
Yep. Thank you very much for the opportunity.
We'll move now to PNM. Debria or Leon, whoever would like to go first, go ahead.
Good afternoon, Mr. Mueller. Good afternoon, commissioners. Can you hear us okay?
We can.
Good. So Leon, Mr. Viveros and I are going to split the time here. So I'll go first and open up, and then I'm going to shift to him. So thank you for having us. So I want to start by making clear that PNM supports the policy objectives of this rulemaking. PNM supports fast-tracking interconnection for non-export system. We support the robust use of smart inverters. We support reasonable cost-sharing proposals. The issue that PNM has, the concern that PNM has, is that safety and reliability is paramount, more so for interconnection than just about any other function that the utility conducts in interacting with its customers. And safety and reliability is an overarching concern that has to be a touch point for everything we're talking about in interconnection. And from PNM's perspective, the rules as they stand now, the Commission's draft proposed rules, and then some of the rules offered by IREC as a proposal, do not at this time ensure for safety and reliability from PNM's perspective. There are two options, it seems, in this proceeding for allowing for ensuring for safety and reliability. There's PNM's proposal, which is the utility-specific interconnection manual. And the two criticisms I've heard of those manual today and also in the comments are uniformity and inefficiencies. I'll start with uniformity. Uniformity is a good goal. It's always, it should always be an objective in terms of rulemaking processes for an agency. The problem for New Mexico is there's not uniformity. I think you heard Mr. Desjardins say there's 19 utilities. Each utility has different systems. They have different capabilities. I'll just take for an example, PNM has Power Clerk. Power Clerk has allowed PNM to interconnect storage systems because of the way it structures the application process. So PNM has already interconnected storage systems. And not all utilities have Power Clerk. We understand some of the rural cooperatives might still be working with paper. So every utility has different systems. They have different functionalities. And when we're talking about the commission's objectives here for really advanced interconnection policies, pretty advanced, I mean, from our perspective, from our review of other states, there are only a handful of states that are going as far as what IREC is proposing for New Mexico to go. And that seems a bit scary to move this fast, that quickly, when only a handful of states have gone that way. So uniformity is a good goal, and that's certainly the objective of our utility-specific interconnection manual. We would like to eventually get to all the advanced interconnection policies the commission proposes, but in order to get there, we're going to have to do it on an incremental basis. And the utility interconnection manual, which will be transparent, we will file for approval with the commission for that. There will be oversight of that manual. The commission will get to approve it. Parties will get to weigh in on it. The manual will be updated. It will be incremental changes in order to get all the way to the commission's objectives. That's how PNM has designed its proposal. The other criticism is inefficiency. And I think you heard Mr. Desjardins, I'm sorry if I'm butchering your name, say that, this process is evolving. Advanced interconnection practices are evolving. They certainly are. And this will have to be revisited. I don't know that it's any more or less efficient to update interconnection manuals, utility-specific manuals, as opposed to updating the rules every couple of years. We would argue that it's probably more efficient for the commission and the parties to update the utility-specific manuals. The other option for ensuring safety and reliability, I think you've heard, is to abate this proceeding, give us some more time to work things out, see if there's a base level manual that all the utilities can agree with our partners, with RIA, with IREC. SPS has supported that proposal. PNM certainly would support that proposal if that's the objective the commission wants to get to. We have been actively, IREC was less involved early on in the process of the early stakeholder meetings. And since their involvement's come along and we've reviewed the batteries toolkit, some of these objectives we're getting more comfortable with. But from a trust perspective, I know IREC's comments seem to indicate that we don't trust them, that the screens they've put in place are going to ensure for safety and reliability. I think trust goes both ways. We want to trust what IREC said, but if that's the case, we need more time to wrap our collective brains around that, and I think you saw this in our comments if you read our response comments. At this point in the rulemaking process, we don't even have a common set of definitions we're all working with. We don't seem to be speaking the same language. And so it's hard for us to come up with rules we can all agree with when we're not even speaking the same language. So from that perspective, we would certainly support SPS's proposal to take a step back, see if we can come up with a uniform set of rules in a manual, or one, if there's not going to be a manual, just one set of rules we can all work with. So one of the big themes of IREC's criticisms of PNM's comments is why are we concerned about safety and reliability? I'm going to touch on those from a broad perspective. I'm going to let Mr. Viveros, who's way more talented in that respect, kind of jump in here. But I'll try to touch on some of those, and I'm going to shift to him. Feeders. PNM has 19 feeders at our capacity. There is this idea that the pathway to open those closed feeders is non-export. PNM does not agree that that's a pathway. Those feeders are closed for capacity. Non-export will not solve the load issues that will occur with those feeders. And again, I'll let Mr. Viveros talk about why those closed feeders, why non-export does not solve that issue. Just, I want to touch on this too. It's come up that PNM closes its feeders to capacity, or I'm sorry, that it restricts its capacity on its feeders. It does not. There's a 50-50 split, 50-50 for behind the meter and front of the meter. It's difficult for if the front of the meter project takes all the capacity, feeder capacity, then PNM can no longer interconnect residential behind the meter net metering projects. We want to make sure we're not restricting capacity on the feeder. We're keeping some capacity for behind the meter residential solar, which also is an important policy objective of the commission. Certainly one of our safety concerns is voltage issues. Non-export reduces minimum load. When PV comes on, it lowers daytime minimum load. It has all sorts of repercussions. Again, this is why non-export does not solve the closed feeder issue. We have inverter, in terms of implementing smart inverters. Again, as I said at the onset, PNM supports robust use of smart inverters, but 1547-2018 has not been implemented. Inverters are not yet certified. Or there's no inverters certified on 1547-2018 in totality. We're only up to supplement B. That's an evolving process that's going on. This is where an interconnection, utility-specific interconnection manual can move and shift with inverter technology. So the last thing I'll touch on from other reliability perspectives, so I can let Mr. Viveros jump in here, is if the screens that are proposed, both in the proposed rules and from IREC, are not helping us identify issues that are happening in real life. And then Mr. Viveros has some examples of this that we can really nail down. In a heavy PV system, the process is getting more complex for interconnection and not less. And there are examples where these screens will not necessarily help us identify in a fast track situation what systems are really going to cause problems. So I'm going to turn it over to you so I don't take all the time.
Yeah, and I'll start as a segue of what you mentioned last. And I don't know if Michael Robb is on, but I remember a presentation he provided to the working group in which he states that, you know, as PV penetration increases, the complexity of the studies will also increase, and thus the timelines to study those projects. So that's normal. I was reading a study from Berkeley where they state that the normal interconnection time for interconnection of any large project went from 2.1 years to 3.7 years as we currently stand. And this is a national percentage. Only 23% of those projects that are in the queues end up being built. In terms of some of the comments that really worry us in terms of safety and reliability, Debria mentioned, and IREC also commented on operational flexibility, which is a 50-50 reservation. It is not an operational flexibility, it's an operational necessity. And the reason for that being is because we need to consider contingency options. So when there is an outage and we need to transfer the load and the generation to another feeder that is working, you know, we could run into problems if we don't consider that capacity. So I think it was stated that there was no technical reason. There is a technical reason behind that request. In terms of the feeders at capacity, we don't believe that it's been understood that we have interconnected 100% of capacity for generation onto those feeders. Unlike many utilities in the United States, interconnecting on those feeders with non-export systems will further reduce the load on those feeders and increases the chances of over-generation going back to the substation, which is something we really don't want. On another point, IREC forgot or omitted the charging aspect of energy storage to be considered as a screen. which to us is very worrisome. There is jurisdictions such as Tucson Electric that mandates that if your system is beyond 10 kilowatts, you are to be on a dedicated transformer. We're not being prescriptive in that respect, but we are worried that, if we're saying that we can interconnect all these systems behind a transformer and we don't study how those systems might charge from the grid, we'll run into safety issues. On another note, on a feeder that hasn't been heavily penetrated by PV, we have customers that are experiencing high voltage rises, and we've implemented smart inverter settings just to find out that having one inverter with those settings isn't enough to correct those voltage rise issues, to the point where the customer decided that now they want to do non-export because their neighbors are complaining that voltage rise issues are creating problems for them. And it was so interesting to find out that once those settings were implemented on that inverter, once a software update came through, all those initial settings were lost for voltage regulation. So if we don't have technology like AMI, honestly, we're flying blind. We can't see what's going on the grid. And that is tied to the fact that we would like to be able to obtain 1-line diagrams, 3-line diagrams. We would like to be able to meter and have disconnects in the systems. I'll just give a brief example. What happens when you can't isolate a PV from a home, from the grid? Our only option is to pull that meter and leave that premises without power. Why would we want to do that? I think the customers would complain. And just in general, our group looks after ratepayers. It is our interest and passion to interconnect as many people as we can, because we see in PNM 100% renewable energy future, right? So screens, for example, like 15%, they no longer capture what's going on. We need better screening methodologies and technologies. And I think that's one of the comments that we've included in our testimony. I don't know if there's any questions that commissioners or participants would like answered. I think there's some in the chat.
I have one question that has given me a little bit of confusion, and I totally respect safety and for all workers and for the grid. But one thing that confuses me a little bit is that we've said, I understand it's PNM's practice to reserve the feeder capacity 50% for front of the meter, 50% for back of the meter. But I think I've also read a comment that PNM has states that the majority of the projects expects to be front of the meter. So my confusion comes from, if you majority to me means greater than 50%. If we have a different number in mind for what we think the projects are actually going to be, percentage-wise from front of the meter to back of the meter, would PNM's practice of 50-50 be different at some point?
Well, Mr. Miller, I certainly, PNM has not to the best of our recollection, I just told those of us here, we've not said that we expect the majority to be in front of the meter. We have a lot of behind the meter residential interconnections on feeders. I don't know the exact percentages of those time, but we could certainly try to do some investigation. I think this is one of the advantages of a utility specific interconnection manual. that's something that the PNM can propose. If that's what we're going to use, that 50-50 split, or maybe after some investigation, we would agree to adjust a bit. That's something that can be proposed in a utility specific manual, and the commission can say yay or nay. That from a policy perspective, as a commission, is there a choice that should be made in terms of behind the meter versus, you know, front of the meter, like community solar projects? Hopefully, eventually one day we'll get to the fact where we don't have to be making those choices. Feeder capacity can be expanded. We can interconnect everybody as fast as we can on a fast track process. As Mr. Vivero said, we like to interconnect our customers. We want to do that. So hopefully that's not something that will always be a restrictive thing for PNM in the future. But yes, that's an advantage of a utility specific manual. Sorry, go ahead.
I would like to add that we never reject any interconnection applications. We never reject interconnection applications. We go through the studies in places where the feeders, we might be experiencing issues on the feeders. We realize the studies, we give options to the customers as to how they want to proceed. We provide them the cost of the system upgrade so that they can interconnect. And it's really up to them if they want to proceed. So I want to just reiterate that we do not reject interconnection applications for anyone.
Okay, thank you. I don't see any, I'm scanning the chat. There's some commentary, but there are no questions directed toward PNM. So I'm going to move along to the next speaker, and then if we have more questions at the end, we'll come back to you. Thank you very much. Michael D'Antonio with Excel Energy. Go ahead and unmute yourself.
Can you hear me okay?
Yes, I can. Thank you. Oh, now you're muted though.
Not sure how that happened, but okay, can you hear me now?
I can.
Okay, thank you for the opportunity. I'm just going to go over a little history here and then get into our comments. SBS is an operating company of Excel Energy, and we serve communities in eastern New Mexico and West Texas. Throughout Excel's total service territory, which includes our larger operations in Minnesota and Colorado, we have over 1,900 megawatts of PV connected to our system. We have connected nearly 90,000 systems overall. That includes front of the meter and behind the meter in our total jurisdictions. With respect to community solar projects, which typically range from 1 megawatt to 5 megawatts in size, we have just under 1,000 megawatts connected, accounting for over 500 systems. So that makes it about an average of 2 megawatts per system on the front of the meter systems. And then we have more projects in the queue. We have participated in 3 other significant interconnection rulemakings in states we serve and continue to seek ways to process interconnection applications efficiently while ensuring that the safety and reliability of our system is met. We appreciate the opportunity to provide comments at this important hearing. We have filed our initial comments and response comments for this rulemaking, so we'll only provide high-level comments today. The Commission has some important decisions to make in providing a balanced rule to ensure safety and reliability of the grid while providing reasonable interconnection requirements for distributed energy resources that interconnect with utilities systems. Although we believe in establishing new and reasonable interconnection standards for developers, SBS wants to reiterate that it is responsible for maintaining the safe and reliable operation of its electric grid for its more than 130,000 customers in New Mexico. This concern is reflected in our initial comments and our response comments filed to date. The adoption level of large energy storage on the distribution system is low today, and SBS is concerned that proposed rules around non-export systems and using screens based on export capacity are too prescriptive given the industry's lack of breadth in operational experience on large distribution connected energy storage systems. Larger energy storage systems are more complex. For example, they may require more complex protection schemes, which may need to be reviewed in more detail. They also contribute to fault current, and screens would need to catch this. The company has an interest in having efficient screens in place to meet interconnection-related study timelines. SPS needs to strike the right balance between eliminating screens and ensuring we properly analyze scenarios where system reliability and safety could be impacted. Because there's a lack of robust utility field experience with larger devices, further field experience with these devices could result in changes to those standards, certifications, and utility-specific technical interconnection requirements. This is why it's important to have the flexibility to adapt to those changes as they occur. We've detailed on our comments where we think flexibility in screens and the use of tools are needed. This is especially important when operational experience is limited due to low adoption. To the extent that the Commission is considering a utility-specific manual, our view, and SPS supports the use of technical manuals to clarify technical issues and requirements pertinent to each utility system. We don't consider it it's not a separate process manual requiring different screens, timeframes, et cetera. SPS would oppose requiring Commission approval of the technical manuals currently in use by utilities, because SPS views the purpose of such manuals is not to override the rules, but to complement them. So it's a little bit different viewpoint than expressed by the other utilities. With regards to specific issues that the Public Regulation Commission asked us to address, I will offer the following comments. You asked about whether the cost sharing section should be deleted, retained as a placeholder, or kept in place. We recommend deletion. We would like to defer the issue to grid mod rulemaking and as recommended by El Paso Electric and others. The timeline extension question, what are realistic extensions? We feel like the timing should be aligned with the SGIP model. Also need allowance for adjustments based on periods of high volume of interconnection applications. The question on feeder line capacity with regards to reservation of capacity for behind the meter projects. SPS supports reserving feeder capacity for behind the meter projects. While SPS we don't practice reserving capacity now as not currently needed because the level of interconnection is not that high right now. We support the ability to implement in the future as more front of the meter DERs are interconnected to our system, which may adversely affect the ability of smaller behind the meter customers to interconnect. The question on treatment of front of the meter and back of the meter systems. SPS supports a separate interconnection queue for front of the meter and back of the meter projects, but it should be utility specific and at the discretion of a utility to implement. And lastly, definitions of minor and material modification. Our comment there is that you need to clarify the minor modification is not the same thing as a non-material modification. We have made some detailed comments in that in our filings, so I won't go into any more detail there. In closing, given the complicated nature of this rulemaking, and to the extent the Commission is considering adoption of IREC's proposal, additional working group meetings with all stakeholders before the adoption of the rule are recommended to clarify some critical technical concerns with the draft rule, particularly concerns related to the screening process highlighted by Excel based on its experience in this area. And those conclude my comments.
Great. Thank you very much, Mike, for participating today.
Thank you.
Anastasia Stevens. Go ahead, Anastasia, and unmute yourself.
Good afternoon, everyone. I want to thank the Commission and the parties for having done so much work before the City of Las Cruces showed up. We're late. We don't have the technical expertise to address a lot of these issues. So our comments have been and will continue to be somewhat mostly from a policy perspective. We were motivated also by our direct and general interest in community solar. We hope to represent a variety. We hope that our comments represent a variety of positions and roles. As you know, we actively participate in lots of SPS cases and many rulemakings to represent the interests of utility customers, residential, small commercial, and the city itself, with and without distributed generation in circumstances like this. Our city council is a very strong supporter of renewable energy. Our city standards are higher than the states and the PRCs. And we've been advocating for community solar for a long time and hope to be able to submit a bid, which colors some of the comments here. So given the overlap with community solar and the imminent turnover of the commission itself, we believe that with some clarification and a few important judgment calls, the commission should go ahead with this rulemaking. P&M throughout seems to be suggesting that the process should start over again and that it can't possibly ever be resolved until all of the variety of ongoing upgrades it has thought about are completed. Well, needless to say, that's a preposterous viewpoint. The commission needs to set a reasonable, progressive, uniform standard in this rule, and then the utilities can come back for variances under standard commission practices, support those variances. The commission should give as narrow as possible variances based on hard, specific facts, not generic claims of we're not ready by the utilities, and should also, in the process of granting variances, should think of timelines. Variances, don't have to be forever.
I'm sorry, please repeat that. Granting variances should think of timelines.
Should think of timelines. Variances do not have to be forever. And the commission can take that into consideration on the record with evidence, and make everybody think through and articulate their specific reasons. Again, there have been a lot of generalities, and I've not been in the working group meeting, so maybe those generalities have been aired in much greater detail, but not everybody knows that, and it's certainly not in writing for somebody who comes in later down the line and wants to understand why one utility is being treated differently than another. So remember, variance, our belief is that narrow variances to a uniform rule is the way to go in this case, and probably in just about every other case. The commission has an obligation to set rules, to regulate utilities. They cannot let everybody run amok and do their own thing just because they feel that their systems are different. That's never been the way it is, and that's not about to become the way utility regulation is. And I've been doing utility regulation for, I don't want to say it, 35 years. Yeah, 35 years plus. So I'm not, trying to be snarky or anything, but the commission has a role, and everybody's got to understand that. Now, picking up quickly on the questions, the city has made clear throughout its comments in this case and in the community solar case that the cost sharing issue should be addressed in a different proceeding, probably or almost certainly the upcoming Grid Modernization Act rulemaking. There have been some comments about the New York State procedure, and I don't know how many of the people here have looked even fleetingly at the New York State procedure, but that's something that's been going on for years, multiple dockets, very many participants. It's a sea change to ask to go from the first payer pays everything model to sharing. And that's going to take a lot of thought and discussion that hasn't been addressed in this case and need not be addressed in this case. The timelines, we does not have specific comments about those. We want them to be reasonable, consistent amongst the utilities, unless a very specific variance can be justified, and importantly, enforced to the extent feasible. Our own experience as an interconnecting customer of El Paso Electric is that the timelines get stretched and stretched and stretched. And we admit that that's both the company's fault, our fault, is our consultant's fault. Those things will happen, but they shouldn't happen unless they really have to happen. And it should be acknowledged by everybody that to the extent that those kinds of delays affect the queue and everybody else in line, that's a bad thing. It's not totally unavoidable, but it is something to be discouraged and avoided as much as possible. And the Commission's third issue is about capacity reservation. We believe that the 50% rule has been largely unexplained. It's never been approved by the Commission, to our understanding. And it represents, in a lot of ways, it represents 100% redundancy on the utility systems. If the utilities were to come in with their loads and resources table and tell the Commission we need 100% reserve margin, it would be hard to accept that as to be taken seriously. So a much more refined analysis needs to be done. With AMS coming, and in the case of El Paso Electric Company, our utility, the city has joined in a stipulation to approve AMS, which is pending before the Commission. There will be a wealth of detailed information about individual feeder lines and substations that will be able to easily inform these sort of customized decisions that should be done in the process. And until then, the utilities should do the best that they can to provide that sort of customized, customer-specific, feeder line-specific analysis, not a one-size-fits-all rule. I believe Ms. Terwilliger said that, or no, it was Mr. Ramirez said that the PNM does not close a feeder without analyzing the proposal. And we had taken their comments in the other way, that they literally do not accept applications. If it's true that they keep the process going, that's good. That should always be the case, as long as the customer is willing to continue paying for studies and discussing ways of achieving the necessary upgrades or determining whether those upgrades are necessary. The process should continue. On the second part of the third question, where city, as stated in our written comments, is open to the idea of separate queues for behind the meter and in front of the meter applications. We seem to see that, maybe this is naive, but we see that as more of a timing issue, because typically larger front of the meter projects take a longer time to be determined, and potentially could clog the route for small rooftop solar residential behind the meters. But I don't think that the behind the meter and front of the meter line is as absolute as everybody seems to think, because there are fairly large large-ish behind the meter applications where customers are using some of the power, and there can be some small in front of the meter applications. The city, in doing a series of projects, has worked out with El Paso Electric that for technical reasons, one or two of their facilities will be in front of the meter, even though their purpose is to serve on-site loads. So just that's just a little bit of experience that it's not a fixed absolute dichotomy. And other questions about behind the meter and front of the meter are technical ones that are better spoken for by other people. As far as the last question on minor and material modifications, we agree, and our comment was going to be the same as Mr. D'Antonio's, that the way that those terms are used in the rule are in different contexts. They're not mutually exclusive terms. And in the final read, we hope that the commission paid attention to that and does not assume that they are, again, black and white dichotomy, because they are for different purposes. And with that, I'll answer any questions, but thank you very, very much for the opportunity to be heard as latecomers to the process. Thank you.
Thank you for participating today, Anastasia. Next, I have Ron Moss with EPE. Ron, go ahead and unmute yourself.
Thank you, Mr. Muller. My name is Ron Moss. I'm speaking today on behalf of El Paso Electric. EPE agrees that it's time to update Rule 568, and EPE appreciates the efforts by the commissioners, by the commission staff, and by all the other stakeholders to develop a new interconnection rule. At a high level, I think it's fair to say that all of the participants in this rulemaking have the same overarching goals, and those goals are a safe and reliable grid, an efficient interconnection study process, and a fair allocation of the costs necessary to interconnect new generation. Where we differ is in the details of how to accomplish those goals. So let me start with the first overarching goal, which is to maintain a safe and reliable grid. Insofar as reliability and safety are concerned, EPE has two major concerns with the proposals in this case. First, EPE disagrees with the arguments that a utility should be prohibited from reserving feeder capacity. As EPE explained in its written comments, it's necessary to have feeder capacity available to absorb the incremental load and generation when nearby feeders are taken out of service because of emergencies or maintenance or other types of repairs. Now, based on the positions taken in the written comments, and again today here in the oral comments, it appears that some stakeholders either don't agree with the premise that utilities need to maintain feeder capacity, or they simply don't understand why the utilities believe that the spare capacity is needed. I believe Ms. Stevens just said utilities haven't explained it very well. That's why EPE offered in its response comments to host a video conference in which one of EPE's distribution engineers will present examples showing why the spare feeder capacity is necessary. It seems to me right now that the stakeholders are talking past each other on this issue, and it would be helpful to discuss this issue based on some concrete examples. Now, perhaps the utilities will convince the other stakeholders that the spare feeder capacity is necessary, or maybe the other stakeholders will convince the utilities that their concerns about spare feeder capacity are misguided. But either way, I think that the representatives and the commission representatives and the stakeholders will emerge from those meetings with a better understanding of the others' perspectives. EPE's second major concern with respect to safety and reliability centers around the concept of export capacity. And I know we've already talked about that some today. But at this point, it's still not clear to EPE how utilities can ensure that generators do not exceed their export limits. And I know PNM's representative spoke about that to some extent earlier. It's also unclear what the utility's remedy would be if these export limits were breached. Now, I'm not saying that these are insurmountable hurdles. EPE might be able to get comfortable with export capacity, using export capacity if it had more information and more time to explore this issue, but at this point, we simply don't have enough information to feel comfortable about this. So let me turn now to the second shared goal that I talked about earlier, which is an efficient interconnection study process. In EPE's view, the Commission's proposed rule would not promote efficiency, in part because we don't really understand the whole way that the level 2 is organized in the rule. And it's not clear what the timelines are for level 3 applications. Now, I would say IREC's proposed rule is better organized, and we appreciate IREC's efforts to draft a clearer rule. The problem that we have with IREC's proposal is that it's overly prescriptive and doesn't account for the differences between the distribution grids of the New Mexico investor-owned utilities and the co-ops. And those are why, in its response comments, EPE supported PNM's proposal that each utility be allowed to have its own interconnection manual. EP's other major concern about the interconnection study process is about the timelines proposed in the rule. In our view, those timelines are too short, particularly for system impact studies and facility studies. I can't speak for the investor-owned utilities or co-ops, but EPE needs at least 45 business days to perform a system impact study and an additional 45 business days to perform a facility study. And moreover, those timelines may need to be extended if EPE receives a lot of applications at once. I know everybody thinks that their application is the most important, and it is to them, but the utilities have to deal with all the applications, not just one individual application. So if there's so 45 business days plus a reasonable provision for an extension if there are a lot of applications at once. If there's no provision for an extension in the rule, then we would ask for 60 business days to perform the system impact study and an additional 60 business days to perform facility studies, because we do have resource constraints. And those resource constraints brings me to the third and final goal that I mentioned earlier, which is the fair allocation of costs among interconnecting generators and customers. Now, Ms. Wazowski said earlier, well, the Commission should require utilities to do this, to do this, and to do this, and to do this. And that costs money. Those things don't just happen on their own. So, for example, if the deadlines to complete interconnection studies are shortened, or if the reporting requirements are inserted, or if the online requirements are mandated, EPE is going to have to hire additional employees. If we have to determine the relevant minimum load, we're going to have to make capital investments to put SCADA equipment on our facilities. Those incremental dollars have to come from somewhere. They either come from the generators who are interconnecting, or they come from the customers. Now, it's the Commission's responsibility to decide who's going to pay for those costs. And of course, EPE will comply with whatever cost allocation decisions that the Commission makes. But for purposes of this rulemaking proceeding, EPE believes it's important for everybody to recognize that these additional burdens bring additional costs that someone's going to have to pay. In addition, EPE strongly urges the Commission to remove proposed Rule 568.16, which is the cost sharing rule. As currently drafted, that rule provision of the rule does not provide enough details for the stakeholders to determine when or under what conditions cost sharing is appropriate. And I would echo Ms. Stevens by saying, in addition, the criteria, I don't think she said this, but I would say that this is more appropriate for the grid modernization proceeding, because the criteria are actually from the grid modernization rule, or statute rather. And so therefore it would seem appropriate to address it over there, or in a standalone proceeding where these issues can be fleshed out in more detail. Finally, EPE recommends that the Commission allow separate queues for front of the meter and back of the meter application, or behind the meter applications, I should say. In our view, there's no valid reason to require that behind the meter applications wait behind front of the meter applications, especially when the two types of applications are processed by different groups within the utility, as is the case for EPE. At the very least, the utility should have the option to put them in the same queue or a separate queue. In closing, I'd like to say that EPE appreciates the opportunity to provide these comments in this public hearing. If anyone has questions, I'll try to answer them. If I can't answer them, we also have Roberto Favela and William Pollard on the call here, and they may be able to answer some of the more technical questions. Again, thank you to the commission, all the stakeholders for your hard work on this rule.
Thank you very much, Ron. Appreciate your comments. I will throw there was one question in the chat that, since you kind of touched on it there at the end, I'll let you take first swing at it, and then if anyone else wants to comment on it, I'll open up. But how would two separate queues for front of the meter and back of the meter work in practice? If the commission were to agree that separate queues give a little more description of how that would work in practice?
Well, may I ask Mr. Favela to do that, since he's, or Mr. Pollard, since they're more familiar with the way that they run these interconnection queues?
Absolutely. If he could introduce himself with his full name for the court reporter.
I'll go ahead and answer this. This is Roberto Favela, manager of system interconnections. And basically, the current system we have in EPE, we have two separate queues for behind the meter and front of the meter. So that's what we have going on right now. Behind the meter applications are typically very small residential and small commercial applications. Very fast turnarounds. We have timelines. We have a method of communicating and coordinating with the customer at different steps. In front of the meter applications, they're typically very large ones that require a lot more in-phase interaction and coordination with the customer itself, specific meetings. So putting a separate queue allows us to sort of allow the small ones to move very fast through the queue and be commissioned and implemented through one group that just specializes on those. We have another group, which is my group, which is for the front of the meter. We do the more technical and lengthy studies, which we assess the full impact on the system, depending if it's 1 megawatt, 5 or 10 megawatt project. Putting all those together will force us to sort of have everybody behind the meter applications, small residentials, wait until the very large application for let's say 5 megawatts is complete, and then process the others. So keeping that separation, which is what most utilities do in effect, also, they treat them and handle them separately. Allowing also for the queue separation allows people who have a vested interest on connecting to a small residential or residential section or part of the feeder to look at how that feeder is being impacted just by that number of small applications. Versus the other one, which we have a public queue and we post those, people can see how many of those customers are truly impacted. If you put everything into one, there's a lot of things that get lost. So it's just a matter of being efficient and being customer responsive. And we do this for the benefit of the customer and also the benefit of maximizing our resources and provide timeline fast turnarounds for the studies and interconnections. That's in a nutshell there.
Okay, thank you. Philip Metzger, I see you have your hand up. Did you have a question that you wanted to ask?
We just wanted to add commentary to what Roberto Favela just stated, and in support of having two queues. And the reason for that is because when you commingle the queues, because of the different timelines for construction, it won't work, right? A really large system takes more time to build than a smaller one. We brought this up before the working group, but it hasn't been addressed. Thank you.
Thank you. And I think the individual who answered the question does seem to feel that addresses her question. So with that, I don't see anyone else with a hand or question in the chat. So I'll go to the last speaker. Sky Stanfield with IREC. Sky, if you're on, go ahead and unmute yourself.
Thank you. Thank you, Hans, and thank you, commissioners. My name is Sky Stanfield. I'm an attorney with Shute Mahaly and Weinberger, and I'm here on behalf of the Interstate Renewable Energy Council. IREC is pleased to see that the commission has decided to update New Mexico's interconnection rules and merge them with the manual. A lot has changed since these were adopted well over a decade ago. At the outset, IREC wants to acknowledge that we appreciate the apprehension the utilities have about changing a process that they know well. But the practices and policies currently in place are not suited to the current DR market demands or technologies. The commission has invested substantial time and effort into this rulemaking, starting with a lengthy workshop process, leading to an initial and then a revised NOPR with long comment periods. IREC urges the commission to stick to this process and not allow the utilities to file separate technical manuals that supersede the work done in this proceeding, although we are open to technical manuals that do not supersede what's in the rule. The utilities have had the opportunity to concretely identify their concerns and present counterproposals to the commission in this proceeding. A number of the utilities have expressed concerns about the scale of the changes that IREC proposed to the draft rule. And I want to respond to these concerns in two ways. First, much of the red in IREC's proposal is focused on clearly defining steps in the process in ways that closely match the process that already exists in New Mexico. We lay out the same tiered review process using terminology already familiar in the state. And we use the most recent FERC SGIP as the basis for many of the changes, which are the procedures that the utilities expressed a preference for. Some of the procedures that certain utilities are pushing back on are very commonly used across the country in states with high and low DER penetration with large and small utilities. These are well-established practices that we are confident the utilities in New Mexico can adhere to without safety or reliability concerns or requiring incredible amounts of new staff, though we do agree that some new staffing could be required. Second, there are some changes proposed that are relatively new, but they are necessary and are based on careful research, which has built upon processes that have been adopted in other states. In particular, many of the new policies are those that came out of the batteries toolkit. That toolkit represents over 2 years of intensive stakeholder outreach and research, and its recommendations are all supported by a consensus of the project partners, which included utilities and the Electric Power Research Institute. The commission indicated a particular interest in hearing commentary on a couple of topics, and I'll address those now. First, IREC strongly believes that as DER penetration grows, cost-sharing mechanisms are becoming absolutely essential to a functional interconnection process. Numerous states have suffered deeply from the queue congestion and delays that result when individual projects bear costs simply because they're the first ones to trigger them. IREC believes the framework presented in the draft rule does need work. We don't take a position on whether this should be left in as a placeholder or removed and worked out in another proceeding, but we do strongly urge the commission to not give up on this important policy evolution and make sure it goes forward. The next issue is timelines. IREC believes the timelines proposed in the rules are generally reasonable and achievable based upon our national experience, achievable both for large and small utilities. In our response comments, we offered that the timeline for the system impact study process could be extended to 40 business days. And I'll say that we'd be fine with 45 business days, as Mr. Moss indicated. We recommend a full 10 business days for application completeness review. And we note that the draft rule has an extremely generous policy that would allow the utilities to extend timelines by 20 days when they use consultants. Frankly, IREC's a bit concerned that this could be abused, but we also note that this should give the utilities that are more resource constrained some flexibility. I want to address the third and fourth topics together. We're not aware of a single state that has treated front of the meter and behind the meter projects differently in the review process. nor have we seen any technical justification for why they would be subject to different review processes. That proposal is simply unprecedented. We are aware that utilities manage their queues sometimes differently between small and large generators, and I'm happy to talk about that in more detail in the responses. Some states have grappled with the issue of how to ensure that small behind-the-meter projects still have a reasonable opportunity to interconnect and not get caught behind larger projects. IREC is also very sensitive to that concern, but we don't believe that reserving 50% of a feeder's capacity is at all a reasonable way to address this. Reservations are an inadequate policy tool, and we believe better tools exist, such as cost-sharing mechanisms that actually get feeders upgraded. The one state that has tried a straight capacity reservation is South Carolina. And our understanding is that that state is now considering abandoning that approach because that capacity is going unused and circuits are being unnecessarily upgraded as a result. However, if a capacity reservation is established, it needs to be based upon a rational assessment of the potential for behind-the-meter DERs on a feeder. And that may vary depending on the feeder. For example, a reservation might be different on a rural feeder than an urban feeder. And ideally, this should be accompanied by a plan to actually get feeders upgraded when constraints do exist, rather than leaving excess capacity and upgrading circuits if a front of the meter project wants to come on, even though there is available capacity, for example. Finally, the commission asked the parties to speak to the definition of minor and material modifications. And it's definitely easy to see why this is confusing. And I think that there's been quite a bit of clear explanation here. Essentially, a minor system modification refers not to the interconnection applicant modifying its system, but rather modifications to the distribution system that could be made to accommodate a DER. The idea behind a minor system modification is that some amount of changes can be made to the distribution system without triggering the need for a full system impact study or facility study. A material modification, on the other hand, refers to when an interconnection applicant seeks to modify their project. The core question on what should constitute a material modification is whether or not it requires the utility to rescreen or study a project. Doing so is time-consuming for the utility and can impact later queued customers. In this proceeding, there appears to be particular debate about whether the replacement of like-kind inverters should be considered material modifications. And IREC believes it's essential and reasonable to allow true like-kind modifications for two reasons. The first is that like-kind modifications do not result in the need for a restudy. The second is that these changes necessarily arise all the time as equipment availability changes. And most critically, this will arise for nearly every interconnected system, as inverters typically last only about 10 years, while a typical PV system may last 20 years or more. If you require a new interconnection application, every time an inverter needs to be replaced, this could create financial havoc for existing customers, and particularly residential customers, and be a substantial burden on the utility. In my remaining few minutes, I want to touch on a couple of the response comments that we believe kind of misconstrue IREC's proposals. First, SPS argues that eligibility limits for fast track should not be based on a project's export capacity. They note that it's necessary to use nameplate capacity for some of the screens, and IREC fully agrees with that. Certain screens should be evaluated on the basis of the project's full nameplate, and we proposed that change to the screens ourselves. However, this does not have anything to do with the eligibility limit. The screens will do that evaluation. The eligibility limit just limits the ability to conduct the analysis at all. Finally, the batteries toolkit proposed an approach that would allow applicants a limited opportunity to modify their projects directly in response to screening or study results. The proposal narrowly defines the type of changes that can be made and also allows projects only one opportunity to do this in supplemental review and/or study. SPS's objection to this option suggests they may not have read our proposal very carefully. The proposal will not allow projects to make changes that are not designed to directly mitigate screen or study results. nor will it be an opportunity for lazy developers to remedy projects. With the meager information that's currently available to applicants in New Mexico about the distribution system, it's not possible for applicants to know exactly how to design their systems to avoid constraints. Thus, it is not indulgent to provide them an opportunity to do so. IREC hopes that if and when New Mexico utilities adopt robust, technically valid, and data-rich hosting capacity analyses, that this process will be less necessary. But until that time, this is a modest and reasonable proposal that allows them to adapt to existing grid conditions. That's the end of my initial comments, and I have some response comments that I'll make when you open the floor for that. Thank you.
Thank you, Sky. I do have one question for you from PNM. They're asking if the simulations that were used to put together in the batteries toolkit considered the modeling of secondary services in their model for analysis.
I'm going to turn to IREC's engineer, Midhat Mafazi, and see if he can answer that. And if not, we can get back to you on it. Midhat, do you know the answer to that?
Yeah, can you rephrase the question again? I'm looking at it, but I'm not following the question.
PNM, would you like to restate the question, please?
Sure, it might be easier spoken. So what we're wondering is, in your batteries toolkit, you went through simulations and analysis of different feeders. My question is, in those models that you utilize for the analysis, were the secondary services model to include the transformers where the services are being fed from, or was just the primary considered for these?
Yeah, so yeah, thanks for the question. It's a good question.
Real quick, before you answer the question, let me just go ahead and state your full name for the court reporter.
Yeah, Midhat Mafazi with I'm an engineer with IREC. Yeah, I appreciate the question. So yeah, the simulation was done by EPRI, and that's really just one chapter from the toolkit. What it does with the simulation, what EPRI did is they assumed a voltage drop for the secondary. So typically, like for example, if you do your simulations in Synergy, for example, for your power flow, you'd assume a 3.5 or 4 voltage drop within the simulation. So they did not do a secondary analysis, but they did it within OpenDSS, assuming that voltage drop. I hope that answers your question.
Thank you. Yeah, it does.
And Ron, I see you have your hand raised. Ron Moss.
Yes, sir. I think there's a little bit of confusion about the reservation of 50% of the feeder capacity. It's not that we're saying we say 50% back and no one can use that. And since Mr. Favela is actually more familiar with this, I'd like to ask him to explain this a little more. And also just reiterate that our offer stands open to have a more robust discussion about this at a subsequent meeting if there's time between now and the when the record closes. But in the meantime, I'd like for Mr. Favela to go ahead, or Mr. Pollard, whoever, to go ahead and explain what this policy is and whether we really are shutting people off from getting interconnected.
This is William Pollard. I can take on that response. Yeah, it sounded like there was a little confusion. What we're talking about is 50% of the circuit rating would be utilized by front of the meter systems, and the other 50% is utilized by behind the meter systems, which would total 100% of the feeder rating, not necessarily holding any additional reserve capacity. Now, what that does is that allows us, because front of the meter systems are the systems that penetrate the system more intently. So when we do maintenance and things like that, it does cause us issues if we have multiple front of the meter systems that are fairly large and we have to provide service to other circuits. Some cases we may have to curtail a system to manage it, or we really have to strongly consider when we're able to perform different maintenance activities as well. Now outages, that's a whole different story. But that was, we just wanted to clarify that we're not, we're proposing utilizing the capacity, just different allocations.
So if I understand it correctly though, so if once a front of the meter project or multiple front of the meter projects gets up to 50% of that equipment capacity, and the behind the meter projects haven't yet used their 50%, so there's remaining 40% of the feeder capacity, you would require the front of the meter project to upgrade the circuit to expand the capacity?
No, we can't necessarily upgrade the system. The proposal would be to connect to a different location. You know, let's say for instance, our cup size is 10 megawatts. We have a 5 megawatt, front of the meter connection on it. Another 5 megawatt comes in, they want to propose connecting. At that point, it would close out the feeder, right? If that connection was allowed, because the cup capacity is full, we would have to move or build another circuit. So our proposal is that instead of connecting to that specific circuit, we would propose connecting to a nearby circuit or provide some other solution to that front of the meter, which still leaves the behind the meter connectivity, and we don't saturate the systems where we can, these systems essentially interconnect to each other. Our feeders can connect to 1, 2, 3, 4 other circuits. So we have to consider the reliability aspects of both load and generation. Now, our planning process, we don't load up our feeders to capacity either. We do target a 50% to 70% load capacity on the circuits. Of course, that's what we plan to have connect. Now, sometimes it goes all the way up to 80 or 90%, but for reliability purposes, so we have switching availability. That's how we plan our system for load. So we would like to consider planning similarly for generation as well.
So I think, I think that was a helpful explanation. Doesn't really change what IREC's perspective is on this, and I think it highlights it that there's capacity that's potentially available, and instead you're requiring either construction of a new line, which is likely to be cost prohibitive, or of using another feeder, which may or may not be feasible depending on the location of the project. And I'll take this opportunity to respond to the sort of broader comments about operational flexibility as well. Again, I think that IREC's perspective is being slightly misconstrued here. So we stated this very clearly in our comments, we agree that operational flexibility is a necessity. However, we've worked on operational flexibility across the United States, and we've never seen in a public proceeding, it doesn't mean that utilities aren't using this practice that we have not learned of, utilities reserving 50% of a feeder blanket across the board to enable operational flexibility. And I understand some of that 50% might be used by small projects. Instead, we aren't saying that you don't consider operational flexibility. We agree that that's something that has to be evaluated, but that you don't use a bright line rule that applies to every feeder, and instead that it be evaluated through the study process to determine what operational flexibility options are available and how much, or if any, constraint the project will put on it. The operational flexibility, as you noted, it depends on the feeder. There's a lot of different configurations that may be available. So we're not saying that operational flexibility should not be considered in the process. We're saying that we think a 50% limitation that as it's being designed is maybe too conservative in some cases, and maybe in other cases it's not. But it's not, but a bright line rule that describes the system consistently like that seems problematic to us, and also seems like a practice that isn't used in other places commonly.
Yeah. And Sky, this is Roberto. I think we're almost saying the same thing. As we know, we have DG, and the penetration is sometimes we have 25-30% of our feeder already penetrated by the behind the meter facilities. So if we allow for the other 100, then we will have 130%. When we have to do the switching, that's when it get problematic. We're not saying we want to have be very flexible in the operational, but we do need that flexibility. And we feel that right now, with what we know, where we have 50% is a good rule of thumb. Does Ty's group allow for flexibility? Absolutely, but that will be on a case-by-case basis. What we want to have is at least the guideline there that allows us for the 50%, because if we don't, then other people will start demanding having more and more. And that, the ones who have to operate and manage the system, and this is system-wide, I came from 3 other utilities, so we did that in distribution and the other utilities as well. I don't know if they had those in the proceedings, but that flexibility has to exist so that people, depending on how many connections you have to be able to operate and maintain your system during outages and keep that reliability. And reliability is the key part here. We have to have at all times that system reliable. So does it always apply at 50%? Maybe not. Can we be more flexible? Yes, probably in some instances, but not in all instances. As I just gave you the case, 130%, it's way above. And if we only have one type, because this is a remote feeders, that makes it, troublesome. We do have in some areas BPE feeders.
I'm sorry, please repeat that. We do have what?
Oh, in EPE feeders that are remote, and they only may have one connection to another feeder. If we were to lose that connectivity, transferring that capacity to the other feeder, it's problematic. And that's all we're saying. We just want to have that flexibility, and we fixed the 50% because it's something that's a little bit conservative, true, but it's something that will work in all instances.
Well, I guess, yeah, so I think you're right that we agree that you need flexibility. I guess we disagree about whether having, what I'm not sure I understand is a policy that says 50% is not flexibility. It's a policy that's a bright line rule. So that's what we're disagreeing about. And like we said, that we think that the utilities do need an operational flexibility. We worked on this a lot in the context of hosting capacity analyses, for example. It is difficult to model, and it's difficult to say widely whether operational flexibility should be one percentage in any one place. So we do agree that you guys need that flexibility to study and analyze it. We just disagree with the 50% threshold, both being conservative and just being a broad cut that may not be necessary in all places. So but perhaps there's some room for consensus here that not having a bright line policy, but allowing the flexibility is the way to go. And I think that's closer to what IREC has proposed.
And Sky, I think that this is Ron Moss for EPE. I think we are pretty much in agreement. I think what we were reacting to is there's a provision in the rule that says you can't have a reservation of capacity unless you have a technical reason or so forth. And we just don't want some presumption that you can't reserve any capacity unless you come in and prove that you ought to have the right to have that capacity. It ought to be a soft, if there's going to be a presumption, it ought to be a soft presumption on that. The utility ought to have that operational flexibility rather than having to come in every case and prove that it needs to reserve that capacity. Is where we're coming from on that.
Well, I guess it comes down to also what it means to reserve capacity. I think identifying that there's an operational flexibility constraint is different to me than having a reservation of capacity. But I do think we're inching towards a better understanding of an approach that Commission could use here. And I do think that the other language in the rules sort of said something like the 50% or not having an arbitrary limit. And I do think 50%, it seems to me to be arbitrary. And so having one that's more customized, we did a study and we determined that in this case, there is an operational flexibility constraint, describe that constraint and identify the proposed solution. And the proposed solution, by the way, in other states and other utilities don't necessarily prevent the interconnection. You can use flexibility within an interconnection agreement, for example, to have the customer agree to disconnection in the case of a need for a reconfiguration. I use that as an example of why a bright line policy is not necessarily the best approach, and that the study process should be designed to evaluate, provide results, and so the customer can review them and you can have a discussion about whether they're reasonable. The commission will have greater transparency as to the utility's choices in that case. And in a lot of cases, if you show that there is an operational flexibility constraint, that's not going to be contested.
Well,
Ron,
Go ahead.
hold
Go
on
ahead.
one second. I just want to rein this in a little bit. I think this is constructive talk that we've got going in. I've had PNM and Beth Chacon have had their hand raised up. I'd like to refer to them just in case they have a question on this, and I'll come back to you. PNM,
Thank you, Mr. Mueller. This is Debra Twilliger. I'll start, and I will pick up where folks were leaving off on the behind the meter issue, front of the meter issue. In terms of the consideration, the particular consideration that PNM has for behind the meter projects, one thing to note and sort of to keep in mind is that when we're talking about behind the meter projects, those folks can't change their location. So the front of the meter projects might very well be able to change their location. Your house is your house. Your business is your business. If you're going to have behind the meter solar, you're going to net meter. Changing your location is not an option where it might be for a front of the meter commercial project. And I think that's part of the consideration, that the policy consideration the commission really needs to take into account when PNM and EPE have kind of put this 50-50 behind the meter, front of the meter, built that into their processes. And I want to reiterate, we do not restrict applications. The applications come in, we offer them an option for upgrades. It's not a restriction on interconnection applications or other options. It's just kind of keeping this for the behind the meter projects. And we do have a lot of behind the meter penetration. I don't have any figures with me today. I know this discussion's ongoing. I did have some response to some other things that have said, if I can quickly, and I know Mr. Leon here wants to follow up on Midhat's response, and he has a question for him. And I think there's also a question for PNM in the chat. But if you want to keep going on the front of the meter, behind the meter, I can hold off on our other points. It's up to you.
let me just check. Beth Chacon, was your question or hand raised in relation to the ongoing meter discussion, or did you have a different topic?
I'm not hearing that.
You're not hearing me, or?
No, I hear you. I'm not hearing Ms. Chacon.
Yeah, I see she's connected, but I'm not hearing her either.
This is Matt Hagan from Excel Energy. I think we were chatting about her question, but it is a separate topic, so we can defer to.
Okay, I'll come back to you shortly, Matt.
And yeah, so I just wanted to respond to some of the comments that Ms. Stevens raised earlier. In terms of the variance, that the option is there for the utilities to seek a variance from the rule that the commission adopts. We don't disagree with that. That is the truth. In some ways, we see the utility-specific interconnection manual as a much more formalized and transparent version of a variance that becomes a living document that the commission can dictate, timelines for updates. So as Ms. Stevens pointed out, that those variances don't last in perpetuity. They change as PNM system is upgraded, as it gets more comfortable with some of these non-export, export capacity policies, as it becomes more comfortable with the functionality of the smart inverters. That is a living document that can change as we progress in our advance towards the interconnection policies. And what we see the commission's rule as, I want to be clear on this, the commission's rule is the guidepost. I mean, yes, we have proposed that the utility specific manual can sort of overlay that temporarily, but the commission's manual is what we're all driving toward. And that is the uniformity that we should be driving for. And that's the importance of utility regulation. And I will just say, for interconnection purposes, there are currently in rules a notion that there might be utility-specific procedures. Rule 569, we cited in our comments, 569.8A4 says that a utility shall interconnect with any, this is 569, section 8A4, if I wasn't clear, states that a utility shall interconnect with any interconnection customer that meets the utility safety standards. And PNM has a rule in place that got approved by the commission that is their utility-specific safety standards. That is not an uncommon thing to have utility-specific standards in the interconnection world. And I guess I would just note, there's been some discussion that the IREX process is built on processes in other states, and we don't disagree with that. We see some of that in there. But let's take California, for example. There's two examples here. California first took 6 years to incrementally change its interconnection rule over a period of time. We seem to be jumping in with both feet really quickly in a way that is not incremental, does not feel incremental, and feels a little bit like it's risking safety and reliability. And I will also note that under California Rule number 21, each of the IOUs, and I think even some of the other providers in California have their own unique Rule 21. That's a tariff that gets adopted and approved by the commission, much like what we're proposing for a utility-specific manual. So I'm going to punt it to Leon here. He's going to answer that question in the chat, and then I think he has a follow-up question for Midhat, if that's okay.
Yeah, let me go ahead and ask that question so we get that posed. The question was, why can't a smart inverter support non-export storage additions to a feeder if the smart inverter setting is set to keep voltage within a certain acceptable range?
Yeah, you're good.
So this is true, just not on feeders at capacity. Because adding any type of system that will reduce the load will increase the chances of overgeneration.
And I guess one follow-up to that as well is that the smart inverters, like Leon said, smart inverters on a feeder that's not at capacity can address the voltage issues. The concerns we still have with inverters are that they're still in the process of being certified. The certifications are still going through. We have not reached a comfort level, and I know this came up in one of the stakeholder meetings, that one of the things the inverter manufacturers are working on is making sure when there's a hard reset, like you lose power or there's a software upgrade, that the inverter settings don't go back to the manufacturer settings. They go to whatever was reached in the agreement with the utility. That's still an imperfect process. There are some cases where those inverters are going back to their manufacturer setting. And unfortunately, because PNM does not have AMI yet, but it's coming, our application is coming in October. We have no visibility if those inverter settings have gotten, not because of any nefarious conduct or anything on the part of the customer, just because they've gotten reset from a power loss or from a software upgrade. We have no visibility that that's happened. And that's a tough issue, a tough hurdle to get across for us now. Yeah.
My follow-on question for IREX technical experts was, in terms of the model, since you accounted for the secondaries as a voltage drop, is it true that you did not consider the coincidence factor of energy storage charging from those secondaries?
Let me actually jump in here first, partly because Midhat has a child at home with him right now. So I think you're getting at another question that I was hoping to respond to, which is, it is incorrect that IREC forgot about energy storage charging, either in our comments here or in the batteries report. The batteries report in the introduction, if you read it, carefully explains why the batteries report doesn't cover charging, and we also explain this in our comments. Most states, and I believe this is probably true in New Mexico, have rules that govern how you review new applications for new or increased load. And historically, utilities have preferred to review the energy storage charging under those rules. You're able to do the technical analysis that's necessary to evaluate the charging of the storage system under that process that you would is if I was proposing a new load or a substantially increased load. We agree that that is a necessary review. And we also agree that ideally interconnection rules in the future would merge that review to some extent because it's not particularly efficient to have two separate sets of rules. But there isn't existing practices out there. Most utilities want to keep their load rules separate. And so that's why we didn't dive into that in the batteries report or here. We are not saying that you do not consider the charging. That is an important factor that needs to be evaluated. However, it's separate from what the interconnection rules typically cover, which is the generation or the export review. So we really appreciate you flagging that as an important thing to consider. And it's not that we forgot about it. We're just looking at your actual capability to do that under your existing load review process.
Let me jump back to, I've got a couple raised comments, and then I kind of want to, I think we're getting to the point where we can wrap things up. Matt Hagan with Excel.
Yes, thank you. So this is a question about the batteries document, and it's a high level generic question. So you said that the document was consensus based, and we were SPS was wondering how the feedback was gathered from the utilities. Like how many responded, what was the level of response, what was the process that you took to get that feedback from the utilities?
Sure, and that's a good question. So the way the batteries project worked is we started by conducting a number of workshops, and I know that Excel actually participated in a number of those. And during that process, we gathered sort of a list of what were the critical energy storage issues that people were looking for guidance on for interconnection procedures. And that included utilities across the United States, energy storage and solar stakeholders. And then with those, we whittled down the list to what we could manage within the project and conducted the research with the partners to the project. So the partners to the project included Pacific Core and New Hampshire Electric Co-op and EPRI. And then during the work and development on the specific recommendations, all of the partners that were involved in the project were invited to participate in the development, and then given updates, we gave regular presentations to the group. And then there were multiple rounds of review of the draft and the recommendations and opportunities for the participants to provide input on the rules. And we had a whole structure around what happens if we don't get consensus, but fortunately we were able to get consensus. And then EPRI also did a lot of direct work with utilities around getting their input as well. And I know, for example, that Excel was quite active in some of the things that we were considering. So I hope that answers your question. The consensus was amongst the actual partners to the project, which are all listed in the report.
Yeah, thank you. How did those two utilities get designated as a partner? How were they selected? Were others considered?
They volunteered to participate. I believe we reached out to Excel during the process, but I'm not sure if they wanted to participate. It's a multi-year project, so it was a fairly significant commitment.
All right, I see Mr. Desjardins has his hand up. Jim, do you have a question?
Not really a question, just sort of a comment. I did hear reference that the commission and the rules should be setting guideposts, and that does concern me a bit. I think that inappropriately diminishes the role of the commission, and I might add that the Public Regulation Commission, I think, regulates. So I just want to point that out. Thank you very much.
Thank you. Art, Mr. O'Donnell, do you have a question?
Yes, thank you, Hans, and thank you all for your participation. It's really necessary to air some of these things. I will point out that some of the issues are really late in the proceeding. And so in some senses, the commission is going to be facing some decisions of first impression. One of these is this idea that the utilities should have individual manuals. And I'd like to go back to what Mike D'Antonio from Excel talked about, which is they see a need for a technical guideline document that is separate from the rule and under the current way things are structured under the current manual. And we understand that that's part of the job, right? Is that there are things that go into technical guidelines that provide information to the applicants as to specifics that really should not be in the rule. So we're not opposed to that. But and I'll give you a good example is that in the proposed rule that we have before us, we're going to be requiring adoption of advanced inverters. We're going to be identifying the functionalities that those inverters should be capable of. And it's, in all likelihood, we're going to be saying whether those should be enabled or disabled. But the whole issue of settings, right, the thresholds for that doesn't belong in a rule. That belongs in a technical guideline. So we're already thinking that, yeah, the utilities are going to have these guidelines. So Mike and maybe the other utilities, what do you see as being necessary in this separate document, and how can we accommodate that without having individual manuals? Because I'll tell you right now, that's a non-starter because it's going to take you forever to do it.
Yeah, thank you, Art. I would like to call on one of our subject matter experts on maybe talking a little bit of how we do this in, I think it's Minnesota. I don't know, Craig or Matt, if you feel comfortable addressing that and how we actually use the technical man. Is that really the question, Art? How do we use that?
Well, what should the commission say is acceptable in technical guidelines and not in the rule? Just give me a bullet list, right? Just so that I have a sense of kind of where we draw the line.
Matt or Craig, do you have some thoughts on that?
I guess you could look at the technical specifications manual that's used in Minnesota, the TIIR. I know they have kind of a starting point in Minnesota for the TIIR. Yeah, I mean, there's some examples of the technical requirements that we use there in Minnesota and in Colorado.
Can I ask, and what is that called?
Oh, the technical specifications manual.
TAIR?
Oh, technical interconnection interoperability requirements, I believe.
Right. Right. And we've had a discussion about this again in the conversations about the advanced inverter settings. That's the place where those settings go. What else? I mean, I just don't see a need for a separate manual if we have all the processes built into the rule.
Well, the utility has some requirements like operability requirements, like potentially grounding requirements or requirements for a utility AC disconnect for field crews to open a switch. So it's not things that are screened for. It's not anything that would prevent a project from interconnecting. It's just for us to maintain the grid and operate our system reliably and safely. These are our requirements to interconnect.
Okay, all right. So they really are technical, and they really do not belong in the rules. I mean, basically, that's what I'm getting.
Specifics about non-export, which haven't been consensus. I don't know if you all have read the ULCRD document, but not
don't use acronyms on us. Please spell it out.
ULCRD.
Yeah, what is?
It's a document that
certification requirements document is what.
Okay, thank you for Underwriters Laboratory. UL.
Right. It's being used as a reference, but I'm not sure if anybody has actually read the document, because within that document there is no specification about magnitude of the inadvertent export energy or how many times these events can happen. We haven't even talked about that. So that would be good information to go into this separate utility-specific manual.
Okay, all right, great.
You seem to be a little bit confused. Can I clarify anything for you?
Well, we're just getting back to kind of, is it necessary to have separate manuals? The commission's position so far is no. And I'm not really hearing an argument as to why. The utilities have all operated under a standardized manual since the last update in 2008, and now you're all claiming that, oh, we're special, right? We have to have special things. And I'm saying that the special things do exist, but they're very technical in nature and should probably reside in the technical guidelines document, right? Because we're not seeing any distinctions among process that are being argued for here, that PE should be different than PNM in terms of the interconnection application. And that's what the rule and manual were always about. So I don't understand why the utilities just want to keep on delaying implementation of this, is really what it comes down to. And this just seems to be a way that the utilities are trying to delay implementation. But that's my point of view, and that's all I can say.
Yeah, so Mr. O'Donnell, I'd like to respond. This is to Bridgeville with PNM on behalf of PNM. You know, I think we tried to really identify in our opening rule or opening comments in the rule, the red line that was attached to it, the places where we were feeling that not feeling, I guess that's the wrong word. We were thinking that the commission's rule seemed to jump too far, too fast from PNM's perspective. And we had safety and reliability concerns. And that's where we referenced where the utility specific manual might govern. So we have identified places where we think that it may be appropriate for the utility to come to the commission in a very transparent fashion and say, this is what we think we'd like to do for 1 year or 2 years. And instead of what the commission's rule is. I understand the reservation on that. What PNM was trying to get across with the utility specific manual is we agree with the commission. We agree with your policy objectives. We want to fast track these folks. We want to have reasonable cost sharing procedures. We want some of this smart inverter technology to come on and to be able to regulate voltage, but we're just not there yet. And so we're trying to agree with the commission and not delay. That's not the intent is not to delay. The intent is to have an overriding safety and reliability view for PNM specifically at this juncture. And maybe we don't need 19 utility specific manuals. Maybe some of the utilities can comply with the rule as it is. As I said in my earlier comments, it's a much more formalized, transparent way for us to seek variances. It's not a delay tactic. It really isn't.
Okay,
it is a
but
way
I will point this out. In our previous version of the rule, we alluded to a process by which the utilities should go off and craft a new manual and come back in a certain time period. And the utilities objected to that and would not want to proceed in even adopting the rule. So what you're telling me is that you would not want the commission to adopt the rule that we're contemplating now until we see what your individualized manuals are. How long is that going to take? We've heard that it could take a year, right? I don't think that the commission is willing to wait that long.
Well, we didn't say it would take a year. I don't know who that.
Well, that was in the working group discussion about the manuals, in which we gave the utilities the opportunity to try and come up with a manual. And one, they couldn't agree with each other, and two, they couldn't agree on basic premises. So that's why we had to do it the way that we did it. So I'm just finding a difficulty here. And Hans, I'm sorry, I'm going to stop here. I don't want to argue with the utilities. I just find it to be disingenuous that all of your suggestions essentially delay and defer.
I'm going to cut you off there. Yeah. Sky's been very patient with me with their hand up. I'm going to.
Hans, before you, can I just make one comment to that?
Go ahead, Mike.
I guess from our perspective, Art, I think we heard some good dialogue here this afternoon. I mean, with Roberto talking about what the reservation capacity and Sky coming to some kind of understanding, a little bit of each other's position. I think that's really all we're after from our perspective, is some additional dialogue to make sure that we have clarity and can move forward for the benefit of both the utilities and the interconnectors. So that's all I had to say on that.
All right. Thank you, Mike. I appreciate you making that statement. Sky, let me turn the floor back over to you. I know you. Thank you for waiting, and go ahead with your commentary.
Sure, and I'm not going to add on to what this discussion is, although I think it's been productive. I had just had one more little response comment coming out of some of the other earlier comments. So it was mentioned that there's some concern about with the export controls, whether a customer will stick with it or whether they change their export later on. And first of all, I think that we definitely heard that concern and considered that very carefully in the batteries project and worked through what we think are reasonable means, reasonable technical means, and the ULCRD has protections about changes to the software already. But I also want to emphasize that there is always that possibility that a customer, for example, can modify a system after it's interconnected. This is not unique to a battery storage system. It's not unique to any of the smart inverter, for example. A customer can go in and add more panels or do lots of different types of changes. What's important to prevent from that is that you have an interconnection agreement. And I think the utilities made a very good point in their comments that you need to have really good clarity on when a utility can disconnect a system because it is not operating in the way that it was proposed and in the manner in which it is designated in the interconnection agreement. And IREC proposed what we think is some pretty robust language to ensure that that's possible for the utilities. We want to make sure that there are adequate protections for the customer and that there's a reasonable process around that. But I do think, I think this actually arises almost never in practice in our experience, although you guys may have a different experience. But we think that concern is not specific to energy storage and that it should be addressed by having a binding IA and having clear procedures for what happens if a project is operating outside of the bounds of the IA and when and how the utility may disconnect or require a modification accordingly. That was my last little note from the comments.
All right, thank you, Sky. And Ron, I remember I promised I was going to come back to you. So go ahead, Ron.
Yeah, I just want to say one thing in response to what Mr. O'Donnell was saying a moment ago about some of these things have come in pretty late. And I would submit to you that the IREC rule, the wholesale rewriting of the 568-15 was late, and we were reacting to that. As between jumping off into the unknown with something that we haven't had time to vet or an interconnection manual that is specific to EPE, we chose the latter. But we really are fine with the rule incorporating what used to be in the interconnection manual and not having a separate interconnection manual, as long as we're not being asked to absorb something here that came in at the 11th hour that we don't really understand and haven't had time to explore. So I don't think it's just the utilities who are putting things in here at the last minute. Thank you.
Right. Thank you, Ron. Everybody, I think it's been a pretty productive hearing. I think we've gotten some better understanding out of a couple of issues. I do want to address. I know we all probably want to get ready for our weekend here. I do have one question on the chat for PNM, and then I think I'd like to conclude the public hearing. The question to PNM is: inadvertent export events are likely to be on the scale of less than 10 seconds. So there may not be much regulation needed. In terms of magnitude, wouldn't it be up to the nameplate capacity of the DER system? In terms of how frequently these events happen, that would be a good thing to know. PNM, do you have a response to the question?
So the frequency of the events hasn't been discussed, and that could impact the net metering program because, you could be inadvertently export for more than 10 seconds or repeatedly, and then your net metering would be impacted that way. The magnitudes have not been discussed, but as you point out and you assert with your question, there is no such thing as limited export because we would have to look at the full nameplate rating to understand the fault contribution of that DER. And per your statement, it would be the full nameplate rating capacity of that system. So I do appreciate that clarification. That was one of our questions. In terms of the manual, I would like to defer to Debria for that.
Oh, I don't know, Han or Mr. Mueller, is that a question that you want us to answer that?
I think I feel we've addressed that question
Okay,
quite a
we'll leave
bit.
it be.
The question, just so everyone is aware and it's on the record, the question is, would the technical manual be mainly a technical guide to complement the interconnection rule to expound on any technical details that are discussed in the rule? I feel our recent conversation here did cover that.
Yeah.
So I don't feel we need to, yes, the person who asked the question agrees, so. Last hand up, Sky, do you want to add something in conclusion here?
I just wanted to say, and there's up there that I think that what is in the ULCRD might be slightly misconstrued here, but it's important that we be clear that the interconnection rules that IREC proposes using nameplate capacity for the protection or fault current reviews. It would use the full, well, actually, we prefer to use the actual rated fault current, but as a default, you can use the nameplate capacity. We are in full agreement that when you evaluate a system, and if you look at the screens, it's explicit that the nameplate or the actual rated fault current would be what is utilized. And then there is a separate layer of concerns that has been alluded to, and PNM's comments just alluded to, which is, what about net metering? And there are a lot of other aspects around what you want a system to do or have to show. For example, that it's not charging brown power and discharging it onto the system for a net metering credit. Those are real issues, and those are issues that should be addressed in the net metering rules because they're not issues about safety and reliability, they're about net metering. And a number of states have developed some good policies on this, and the power control system can be used in the right way to achieve those goals, but that we consider that to be a separate issue from the interconnection rules. But it is something that needs to be considered in net metering. Thank you.
Thank you. I do not see any further questions. I'm not seeing any further hands raised at this time. Let me just ask our court reporter, Melissa, do you have any questions that you need covered?
I have one observation. There's a lot of people on this Zoom, and I maybe have 31 names, and I think there's a lot more. I don't know the best way to get those to someone central to get it to me. I'd hate to get 100 emails, but I guess somebody has to. So I'm happy to give my email if anybody. I tried to write as many as I could down, but I don't know if we need to have every name listed in the public comment record of who spoke, or if people that were just present need to be listed. I don't know the answer to that.
I believe the people who were speaking, I think either have identified themselves on the record. I do not believe we need a full review of everyone who is just listening. It is my interpretation of the rule.
Okay, that's fine.
They had the option to watch via YouTube or via Zoom. I think they just chose whichever one was more comfortable. Sorry, I'm looking at one last chat, but I think for the record, we just need who the individuals who are speaking.
I can do that. I think I have that.
Okay, thank you. The one last question in chat: will there be an opportunity to file short reply comments? I do not believe a deadline for reply comments is stated in the order. I will probably address the order next week. So everyone probably keep an eye out for that. I don't know if I will necessarily allow for reply comments. I probably would guess that I will extend the date of closure of the record. But there are a couple things that I need to review within the Office of General Counsel. But I would expect some sort of updated order regarding that next week. Overall, I want to thank everybody. I want to thank everyone for their civility and for participating today. I do feel it was a very worthwhile public hearing and really good discussion with everyone who participated, including us being probably a little more liberal with open discussion than in normal public hearings. So I do appreciate everyone waiting their turn, and the civility that was shown toward everybody is much appreciated. With that, I think we are going to be adjourned. And for those of us that have a 3-day weekend ahead, enjoy the 3-day weekend. But clearly, I look forward to moving forward with this rule and everyone's participation. So thank you, everybody. And at this point, I will adjourn the public hearing.
Thank you.
Thank you.
Thanks, Hans.
Thank you.